Hello and welcome. On October the 10th of this year, after a multi-year process of revision and public comment, the new EMS regulations became law. These regulations are the law, and they affect you and me as individual providers, students, educators, and agency representatives. This morning I'm going to be joined by Michael Berg, who's the Compliance Manager for the Office of EMS. We'll try to sort out some of the new regulations, some you may not have seen before, and some that have been changed. Mike Berg, welcome.
Thank you.
After a lot of review of these 216 pages of exciting new regulations, a process that took how many years?
About 9 years to complete.
A process you've got to be glad is over.
I've already been told I need to start it again.
Well, we're just going to do what we've got here in front of us. A lot of people, I don't think, understand where the compliance and regulation department get their authority. They're very familiar with criminal law, maybe traffic law, but this is administrative law.
Correct.
Can you tell us where your authority comes from? And tell us a little bit about the office and its enforcement.
Absolutely. The Office of Emergency Medical Services is part of the Virginia Department of Health. And within the Code of Virginia, which is the law of the land in the Commonwealth, there is a section on Chapter 32.1 which gives the Board of Health the authority to promulgate regulations. And also with those regulations, it gives them the ability to enforce those regulations. There is a process as defined within government how that works. So we're acting on behalf of the Health Commissioner and the Board of Health when these regulations are promulgated and making sure that they meet the minimum standards and requirements as set forth by the Board of Health.
So in saying that, the enforcement that you do is we would normally be familiar with law enforcement officers, police officers. Your law enforcement is done through the agency, the representatives of your agency, the people that we normally see during inspections and...
Right, exactly. I have, I say I, but we have 8 program reps in the field, and they are investigators who do investigations and any concerns or violations of the regulations, as well as doing the agency inspections. They're also technical experts. So they are the Office of EMS. But in accordance to what we're presenting here, they are the enforcers, if you will, of the regulations.
Would it be a reasonable analogy to say that these people would be special agents of the Department of Health in their enforcement?
Yes, they're investigators, and so they do have that authority to do those investigations.
And they have the authority of law when enforcing this particular chapter?
There is law, but there is a due process that goes with that as well.
So the program representatives that you have and go out and visit people, do spot inspections and come to facilities, these individuals actually have the authority of law within these regulations.
That is correct. They represent the Health Department and the Health Commissioner. And if there is a violation of those regulations, have the ability to impose certain enforcement actions. And we can go through those a little bit better so that the audience understands what they are.
Sure. Give us a little explanation of what the sanctions are against a person, maybe whether that is a sanction that's going to happen and be taken against the individual provider, or are these sanctions something that are taken against the agency, or is it a combination of both?
That's a good question. That's something that a lot of folks may not understand. If an individual has created a problem, has not met minimum requirements, the program representative can, in fact, issue a sanction to the individual provider. If it's something, for example, if we're doing an agency inspection and they don't have a copy of the signed contract between the medical director and the agency, that would be an issue for the agency to be addressed. And some of the sanctions that can be imposed, we can start out simply with what's called a verbal warning, which is written, it's kind of a misnomer that it's a verbal warning, but we put it in writing and keep it as a historical document that something wasn't done like it was required, give them an opportunity so when we come back at a defined time period to make sure that it's been done. That would be the least severe sanction, if you will, that can be imposed. We could also issue a citation, which is equivalent to, let's say, a speeding ticket from a police officer. It becomes a public document, and that gets posted on our webpage. And for those people who have gone to the Office of EMS webpage and looked at the citations and the enforcement actions for those individuals or agencies, I can assure you that they have earned the right to be on that webpage, unfortunately. So a citation can be issued, and it may have a requirement in that citation for certain activities to occur within a defined time period. Concurrent with a verbal warning or a citation, we can also issue what's called a correction order. And that is a correction order, is another more defined process of what the expectations are to meet compliance with the regulations. And again, I need to enforce, Tom, that the regulations set minimum standards, minimum requirements, because our responsibility is the health, safety, and welfare of the citizens of the Commonwealth. And we're doing a regulated performance service, and so they have to meet that, make sure those guidelines and standards are met. If in fact the single event or a series of events are severe enough, we can issue a temporary suspension. And an example of that would be a provider who has been charged with some felonious crime that, let's say, involves drugs or sexual nature of that kind. They're considered an immediate threat to the health, safety, and welfare of the citizens of the Commonwealth. And it also protects that provider in the event that they're going through some criminal charges. It does not put them in an environment that could cause them further harm, and at the same time we're protecting the public. An actual suspension of an agency or a suspension of a provider has to come with due process, which means we have to give them an opportunity to be heard and to present any evidence to counter any recommendations that the office in my division would make to the health commissioner for actions to the individual or agency. And the health commissioner usually has, once that hearing is held, up to 90 days to make that decision. And of course, if that decision is not in the favor of the agency or the regulant, they can then pursue either an additional informal hearing, or they can pursue what's called a formal hearing through the Circuit Court of Virginia to have that process done. The last thing that can occur as part of enforcement action is revocation. So suspension means a defined time period, and then you can come back. A revocation in Virginia, as long as I've been in my position, is permanent. Once a revocation has occurred, either a certification or agency license, they're not allowed to come back into the system. Certain crimes, certain felonious crimes will cause a person to have a revocation to occur. Agency revocation has been rare, but it's been after a long, arduous process of trying to be able to get them to do what needs to be done. So those are the levels that can occur. There is one other new enforcement action that, as a result of these regulations, and we can impose what's called civil penalties. And we call them civil penalties because in Virginia law, if you said just a fine, then the monies collected go back into the general fund for the Commonwealth. Civil penalties define those monies into a certain fund. And in this case, they would go to a fund established for the Office of EMS, for Emergency Medical Services. That process is still being completed. And we just were able to start implementing that this year. And the way that it's worded is it's up to $1,000 a day per offense. Again, it's a tool in the toolbox trying to help folks to understand what they need to do. I will also share that that civil penalty is only applicable to agencies and entities and not individuals. For example, we have regulations that oversee the regional councils. And if there was a part of the regulations that a regional council would not adhere to, despite best efforts to work with them through technical assistance, whatever the case may be, you have to come to a point where you may need to reach into your toolbox and use that tool to convince them that this is what they need to do, the right thing to do.
So as a general rule, by the time you get to actual monetary sanctions, there are many steps in the process.
Oh, absolutely.
They're not first out of the gate.
Correct. That is absolutely correct. And we extend a lot of time and effort to work with agencies, individuals, and entities to get them to understand why they need to comply. Now, there's certain things that are done. If you go to court of criminal law and you're convicted by your peers or by a judge, you've already had your due process. And there's nothing else for us to do except follow the administrative part to make sure that we're protecting the health, safety, and welfare.
So there's two things that come to mind, and I've looked at that registry, so to speak, the offenders registry.
Right. Some people call it the wall of shame.
Well, the wall of shame, call it what you will. And the one thing that sort of strikes me oddly is you're on there forever.
Correct.
Was there a particular reason that they chose to do that? I mean, in a lot of other areas of violation in law, traffic records, what have you, there comes a period of time where the less serious things, they'll age off and they'll go away. Was there a reason that they chose, that either the commissioner or the office chose to have these people on there indefinitely?
That's a very good question, and I actually get asked that by certain individuals on a repetitive basis. because they may have erred in their ways, but have since corrected those errors, and it actually become a very positive influence in the field of emergency medical services. We have discussed that. We continue to discuss that. I'm not sure if there's a specific direction from either within the health department or even with our legal advice to the Attorney General's office. I believe that's going to be agency specific. That it's still something that's on our radar to look at to make a decision how long somebody stays on that. I will share with you that if somebody is suspended or revoked, and this is individuals, practitioners is a term I would like to use. The Office of EMS, specifically my position, is a mandated reporter to the National Practitioners Database. And so if an individual is suspended for 30 days or longer, or revoked for 30 days or longer, I have to report them to this national federal organization, and their names stay there forever. So there's a precedence for that. I do understand, like in DMV and some other areas, after a period of time of attrition, things will come off. Those records will always be there if somebody really wants to, under freedom of information, ask for that. And it may come to a point where we may not have enough space because unfortunately, we still do have folks who have challenges and issues.
Are there that many violations occurring that frequently?
Unfortunately, yes. Unfortunately, yes. And you may take an opportunity, look at some other states and what they do. I believe it's New Jersey, when they list their offenses, they list the entire case file for everybody to see, every word that was ever said. It's pretty interesting reading. Yeah, I know in the state of Texas, they have a monthly publication that they do. And the first part of that publication most providers will go to is the back section, which lists all the providers and all the offenses and the agencies and their offenses. So I do appreciate the concern. We just have not come to a consensus as to how best to address that.
So moving on to the regulations themselves, I mean, having gone through this, there seems to be a lot of changes in nomenclature and stuff. Generally the same regulation, language is changed, practitioner names changed, drugs, medications, but not a lot of substance really to that.
No, there wasn't a lot of substance change. We had to make some technical changes where the word, as you indicated, medication, in the Code of Virginia, the medication doesn't appear, it's drug. In some parts of the 2003 regulations, it identified the Office of EMS, and on the advice of the Attorney General's office, we needed to change that to say the Commissioner of Health. So there was a lot of those. But also we made changes to reflect changes in certification names. For example, the enhanced certification will be transitioning to the advanced EMT. There will not be an EMT basic certification. You'll be certified as an EMT to reflect the national certification levels that Virginia's adopted to go with. So the emergency medical responder replaces first responder, emergency medical responder replaces first responder, EMT replaces EMT basic, advanced EMT replaces the enhanced EMT, and then there's not an EMT intermediate, it'll be just intermediate, and there's not an EMT paramedic, it's just paramedic. And all those reflect the national certifications.
So Mike, some of the new guidelines that were more controversial than others. I think one of them that I read in here, and there was a lot of discussion, I remember at the town hall sessions, was permission of firearms in an OEMS vehicle. And it looks like the regulations are now silent on that.
Yes, they are. I'm smiling because in 2003, when these regulations, the previous regulations were promulgated, there were two sections when those regulations talking about the carrying of firearms. And that was the #1 comment made during public comment with regards to changes in the regulations. It was so strong that, in fact, it was removed from the regulations. Unfortunately, on an administrative oversight, one section was removed, the other was not. And that remained in Section 700, I believe, in the 2003 regulations. When I was asked, when I came into my position, what we would do as far as enforcing that, and I've always said that's an agency-specific decision. That was an error that should have been removed. It was not. And that when people ask, if they call and say, I want to carry a gun on the ambulance, can I do that? I say that's up to the agency. That's their own policies, procedures. We will not enforce that regulation. And when these regulations came about, it was an opportunity to remove that language that should have been removed in 2003. So quite honestly, it wasn't a change. It was just an administrative oversight that that language had not been removed. I will share that in the last public comment for the current regulations, that was the #1 commented section where people were glad to see that the restrictions on weapons were removed from the ambulances. And I just simply removed the language that should have been removed in 2003.
So presently, as it stands, any weapon can be carried on any ambulance by any individual.
It's up to the agency if they want to develop any policies or procedures related to that, and your answer is yes.
And absent of that, the sky's the limit, carry what you want.
Correct.
Some of the other things that have changed, there are some reporting requirements now, yearly reporting requirements for the actual agency themselves that appear to have not been in previous regulations. Can you tell us a little bit about them?
Probably the biggest one has to do with the agency developing an emergency response plan in cooperation with the local government and their medical director. There are a significant number of agencies who are recognized by their local government to answer 911 calls on behalf of the local government. But because of either call volume, availability of personnel or equipment for that matter, some calls weren't getting answered, some were getting answered, some were delayed. The whole myriad of what could occur in those situations. And so it was felt by the individuals, the peers who put this together, and I need to emphasize that this was not a Mike Berg sitting behind the desk making this up. This was actually stakeholders of the EMS community, whether they're career personnel, volunteer personnel, administrators, medevac, whatever. These were folks who came together on a regular basis to look at these and make recommendations of what to be changed. And one of the things was that we need to have agencies have a defined plan that includes not only what they're going to do and how fast they're going to do that, or what time frames. They need to establish their own response time criteria from the time they receive the call till the time the ambulance arrives on scene. How often, what bar are they going to set? What measuring are they going to set to make that in? A rural agency may say from the time we get the call till the time the ambulance arrives, we can do that 20 minutes, 90% of the time. Establish that criteria. And then collect that information on an annual basis, and they need to provide that information to their medical director and to the local government and make it available to the Office of EMS. So we want the agencies and working with their local government to make that decision. The local government's responsible under the Code of Virginia to assure the continuous provision of EMS. And for those people who are anal retentive, that's under section 15.2-955, paragraph B, that mandates that local government seeks to assure the continuous provision of EMS. That local government's responsible. They need to make sure the calls are being answered. So if there's an agency who knows they have challenges and issues, may or may not be working on those, but they can come up with a plan. So if a local government X gets a call to agency Y, and agency Y knows they're not going to have somebody there, but the plan is it'll automatically go to agency Z, then the local government has some assurance that that call is going to be answered in a timely fashion.
Now that timely fashion you mentioned when the call is received, is that when the agency receives the call or when their PSAP or 911 center receives a call from a citizen for a call?
And that's a very good question. On a lot of localities, agencies don't have any control over that aspect when the call is received by the 911 agency. So the time measured is from when the agency receives that call from the 911 center.
So dispatch time.
Correct, dispatch time. Because they can't control process time, or, you know, in some areas the 911 centers are not an independent standalone organization. They may be run by the local sheriff's department, as it is in a lot of our rural areas of the Commonwealth. And they're taking care of their other calls as well, and may not necessarily have somebody dedicated to EMS. So we can't control that area. But what we can control is when they do receive that call, and then the time they get an ambulance on scene.
Okay. So looking at the regulations, any changes or any new regulations, what about regulations that would keep us off that, as you described, the wall of shame? Anything new that can get an individual provider inadvertently in trouble?
There's been a little more emphasis on safety for the individual. For example, previously in the 2003 versions, we said no smoking in an ambulance. Most folks complied with that, but we didn't say you couldn't dip You couldn't chew. And so basically in the new regulations, there is no active use of tobacco products in an ambulance. And it has to be an ambulance. I've had folks say, well, but what about my chief's vehicle or my admin vehicle? It specifically says in an ambulance.
Transport vehicle.
Exactly. Another area that has drawn a lot of concern is the use of straps on the stretcher with the patient in place. I have personally seen agencies who bring patients in with one strap, no straps. They may have them on a backboard, perfectly immobilized. They're square knots with their cravats or where the case may be, but they have one strap or no straps holding them on the stretcher. And without boring our viewers, I can cite evidence of cases where patients were appropriately mobilized, put on the stretcher, transporting the patient, and en route to the facility they were going to, the ambulance was involved in an accident.
They become a missile.
And they become a missile. And when I was doing this presentation at an agency not too terribly long ago, I was informed that their insurance carrier, which is a very large insurance carrier that covers a lot of the agencies in the Commonwealth, specifically states in their policy, if you do not use the manufacturer's recommended restraining devices on the stretcher, they will not cover any claims.
So, at minimum, how many straps on a patient?
3 straps, at minimum.
Regardless whether you happen to be equipped with the shoulder straps.
Correct.
To get you through OEMS,
right.
3 straps on
right.
the patient's torso.
And obviously, if you have a patient who their size precludes the use of the top strap, or some condition precludes that, we understand that. And the best way to cover that, of course, is through documentation. So, but yes, that. Another area that we're talking about, agencies and individuals, before when you transported a patient, particularly if you're a first responder agency, or if you're transporting a patient to a facility, you were supposed to leave a copy of your call report, either with the agency that was transporting or with the receiving facility within 24 hours. And the initial public comment, we had a lot of hospitals complaining that patients were being brought in by EMS, dropped off, and they didn't know what was going on with them. And that created a bit of a windstorm. And so the regulations have changed that you need to leave a copy of that completed call report within 12 hours of the patient's transport. And the 12 hours was chosen as part of a compromise to satisfy all the parties involved, but a lot of the shifts are in 12-hour blocks.
Sure.
And so even in the day of electronic reporting, it still becomes a challenge for some agencies, particularly high-volume agencies, to be able to get in and get out to be able to answer the next call.
Well, I know in our agency, for example, we write a brief history and physical note. Mm-hmm. It's longhand. It's left at the ER. The complete electronic chart is submitted, but it's submitted to medical records. So some agencies may well come home, they have their 12 hours, do their electronic report, and is it going to be permissible for that to go to medical record, or does that initial, within 12 hours, have to go to the staff in the emergency room at the receiving facility?
If you look at the wording in the regulations, it says left at the facility. Didn't say where in the facility, but left at the facility. Ideally, it would preclude the agencies and the facilities to have some discussions to see where that should go. I will say also that some of our viewers who may be working with agencies who have hospitals who have the Virginia VFib program, hospitals can subscribe to that, and the agencies can input that information and have live time information.
They can retrieve it.
And they can retrieve it. However, if the hospital, even though they may have access, still says, I want a hard copy, you need to provide them that hard copy.
Okay. One of the other things I looked at in here that had changed was the reporting requirements in criminal histories for people, new associates within 60 days, I believe it is. And that seems to be extended from previously VSIN was acceptable, and now it's a CCRE check and NCIC check. And for those people who are not aware of the difference between NCIC and VSIN, VSIN will give you records and history of offenses here in the Commonwealth, whereas NCIC is going to give you a national database, and in some extent, it will actually include Interpol and other things. So that's a much more stringent requirement much more far-reaching.
Yes.
Any feedback or any problems with getting that through?
Well, again, the stakeholders felt that it was necessary to do a larger search other than just within the Commonwealth. For example, some of the Northern Virginia agencies, they would get people from other states. And we had a couple of cases where people came from other parts of the country to start their lives over in Virginia. And unfortunately, we found out through either using the internet, where somebody had shared some information with us, these people had less than stellar backgrounds. And so, as you had identified, the criminal history report for VSIN only identifies in Virginia challenges and issues. And so we included the NCIC, which is essentially a fingerprint background check by the FBI. The challenge for us, although that was approved by the Attorney General, and they always review these prior to allowing us to move forward to make sure they meet the intent of the law, was that there has to be code language that allows the Commonwealth of Virginia, the Office of EMS, to have that done as part of an affiliation with an agency. There is a bill that's being introduced this particular General Assembly session, which allows that to occur. I have met with Captain Turner of the Virginia State Police, along with other members of the office. Cordial discussion about doing this. They have no problems with doing it. We just need to have the code language changed. And a suggested scenario may be where an individual goes to a facility known as LiveScan, has their fingerprints done, electronically gets submitted to the state police. They run that information, they provide that information back to a governmental entity. More than likely it will be the Office of EMS. We would in turn notify the agency the individual is or is not eligible for affiliation. And it's for anybody who's becoming affiliated with an agency. There are some folks who have some concerns that this is retroactive and they have to do it with everybody. No, it's whenever it goes into effect. And I will provide a memorandum out to the agencies when this becomes effective, once that code language has been changed. And anybody from that point forward that would apply to.
Okay, so presently, if I'm enrolling students or in a course or I have new applicants to come to work, I do not have to do the NCIC check?
That is correct.
Until we have the code language
correct.
To meet that.
Correct. But still have to do the state police background.
Absolutely.
Yes.
And really, we can be as PC as we want about it, but in the past, providing you kept your nose clean in Virginia, you could have been Ted Bundy in Maryland.
And we actually had a couple of cases like that.
Yeah.
That when somebody happened to be searching the internet and they saw this person's name, they called us and said, you may want to check in on this, and we found out there were problems.
Now, the other thing I saw in there is a requirement for a DMV transcript.
Yes.
And that's new.
That's
correct?
new. Agencies should be obtaining that information. One of the other changes we've made, it has to relate to the DUI regulation, and I'll talk about that in a second. But the agencies need to develop a driver release process, and part of that requires a DMV check. A lot of folks may not know that their insurance carrier routinely does background checks, or does DMV record checks.
Absolutely.
And if they start seeing a pattern, they may increase the frequency. A lot of them will do it once a year, but they may increase the frequency. And in some cases, they've actually called the agency and said, person X is not covered by us to operate any of your vehicles. So we're asking people to be a little more business oriented. They do the background checks. I just got a notification of a person who has been charged criminally. But part of our investigative process, we do an automatic DMV background check. He had 14 demerits in his driving record. So do you really want that person driving your vehicles, operating your vehicles who are negligent in their operating of their own vehicles? That's a good question to ask, and the agencies need to address that. So we do require they do that on the initial, and agencies can actually apply to be able to access that information online. It's a secured process through DMV. They can do that.
But as regards the Office of EMS, I'm required to have that transcript with, again, I presume it's within 60 days of
Correct.
affiliation.
Correct. Just those who are affiliated.
With the agency. And I get a guy who's got a lead foot and he's got 36 points.
Which is not unheard of.
But to OEMS, what does that matter? Is there going to be a criteria that's going to be set by you that certain accumulation of points or certain violations are going to be, these folks are going to be excluded from operating emergency vehicles. What interest does the DMV or does the Office of EMS have in that transcript being got if they're not actually setting any rules for it?
That's a good question. We did this, the group that put this together felt this would be a step where an agency can look at these applicants and determine their viability as far as safe operators of vehicles. There was, I'll give you another example. There was an agency not too terribly long ago that did an audit of their driving records, fairly large urban fire suppression organization, and found that 30% of the people that were working for them either had their license had been revoked and or suspended and were operating their equipment unknowingly. So it creates a little bit more responsibility for the agencies and for the individuals. It also requires that the individuals have to report any infractions to their agency within a defined time frame. So
infractions or convictions?
Infractions. If they are charged with, and I'll have to look at the wording, and that's a good question. I have to look to see whether it says convictions or infractions. But if somebody has been charged, and I would lean towards conviction at this point, if they're convicted of a DUI or if they're convicted of a moving violation, they need to notify their agency, because in some cases, depending on that particular conviction, for example, driving greater than 20 miles an hour over the speed limit may preclude their insurance carrier from covering them. And that person may not be able to operate those vehicles. Doesn't affect their certification, so they could still be an attendant in charge, but it may not allow them to drive any of those vehicles for that agency.
Well, there's another thing also when we're talking about operation of vehicles, and correct me if I'm wrong here. Previously, up to this time and this new set of regulations, a conviction for driving under the influence in the Commonwealth or any other similar offense in any other state precluded you from operating an OEMS registered vehicle for 5 years after the disposition. So not 5 years from the day you were arrested, not 5 years from the day the judge convicted you, from whatever terms the court ordered you. In reading this, has that changed?
Yes. Yes, that was another large point of contention, and one of the stakeholder groups had a large concern because they felt that there was some disparate discrimination against career providers, and they were losing their jobs. And quite honestly, it did not affect their certifications, and their jobs was an employee-employer relationship. But what came out of this, as you described in the 2003 regulations, if you were convicted of a DUI, or assigned to an ASAP program under 18.2 of the section of the code, then your privileges to operate a permitted EMS vehicle were removed for a period of 5 years. And in the 4th year, you had to take an EVOC course. That language was crafted after school bus regulations, school bus operator regulations. What has changed now in these regulations, one, if you're convicted of a DUI while operating a permitted EMS vehicle, you're revoked. Your certification is revoked. So that's new. And some people may chuckle, say, well, that never happens. And you would be very surprised.
First time conviction.
You would be very surprised the number of people who go out and either under the influence of alcohol or drugs and are operating this equipment. The other part is now the agency is responsible for developing a program that addresses those issues. And the onus is now on the agency to address it as opposed to the Office of EMS addressing it. And quite honestly, if people were to look at what their insurance carrier will and will not cover, the litany, if you will, of those infractions that may cause them not to allow somebody to operate a vehicle, they would be very surprised. I volunteer with an agency, and as their previous safety officer, and I still do their driver checks for them, the listing when I went through our insurance carrier, there's about 23 items on that list that will say if they have these items, they'll exclude you from operating the vehicle. So yes, the change occurred, the onus is on the agency. And the one big change is that if you're convicted while operating an EMS vehicle, you're revoked, your certification is revoked.
You're gone. And as we've said earlier on, in OEMS world, revocation is a permanent thing. It's gone, it's over.
Correct.
You've got to find a new career.
Correct.
Or a new volunteer agency. Out of the other regulations, and there are many and many new ones, Are there any particular ones that you would like to get out there and let people know about specifically?
There's a couple more for the agencies. There's now a requirement when the agency, and in conjunction with the medical director, as part of the agreement with the medical director, the agency has to have a listing of the personnel, and the medical director on agency letterhead has to sign off that those individuals are authorized to practice under their license. Before, the medical director was just there and may or may not know who was actually working under their authorization. This now needs to be a living document because in some agencies they have monthly turnover. It could be because they may be in your university where kids come and go or something of that nature. So that needs to be an ongoing process. That's new. There is a requirement now for agencies to have an alcohol and substance abuse policy and procedure to include testing. Now, that doesn't say the agency is responsible for paying for the testing, but there needs to be the ability for the agency to address those individuals whom have substance abuse issues and challenges. It's not so much those who have substance abuse issues. I can give you a scenario where a person works at company A and they end up having some type of injury, shoulder injury, back injury, whatever the case may be. Then they go to the doctor, they're put on some type of pain management, and on the side of that bottle it says, do not make legal decisions, operate heavy machinery. So they're out on workman's comp, so they'll go to their volunteer squad that they're with and start running calls because they now have all this available time. Well, if they can't work and they're on pain management, why should they be on the ambulance? It was not uncommon for us to receive a couple times a month complaints or concerns about providers not acting appropriately. And come and find out they were under the influence of their pain management or their psychotropic drugs for that matter. So that needs to be addressed by the agency. It may say, we're not going to do anything about it. It can be very convoluted, but it's the agency's responsibility. So that's something new as well.
But in policy, there must be something written to some way address this particular issue.
Absolutely.
What you say in your policy is up to your agency, but you must have a policy saying something. Basically.
Exactly. And I also express this is a great opportunity for agencies and regional councils, and in some cases, some healthcare industries to reach out and partner under certain programs. For example, a volunteer agency and county Y, it's a great time for them to reach out, and potentially the county can offer that as part of their EAP program for the volunteers of that agency as well. So there are ways to address it, but the bottom line is it's not an OEMS issue, it's an agency issue that needs to be addressed.
Lots of new changes with nomenclature and what we're called, who's a medic, who's not a medic, what you do with your class, who can teach what classes nowadays. For the students taking classes going forward from now, is there anything new that they're going to need to know in order to smooth their process through their class?
Wow. Everything's getting longer. Even for me, as I've been an EMT instructor forever. Now I'm an EMS education coordinator.
That's what
I'm
we
an
are.
EC, as opposed to being an EMT instructor. I'm an EC. The EMT class, wow. The state has adopted the federal curricula, if you will. And so the EMT program is like over 154 hours. It's much longer. That creates challenges for some of our jurisdictional agencies who hold academies. Before they used to be able to, they had this 120-hour program, they had it all figured out. So now this additional time, and some of that time has to do with some of the NEMS compliance and some of the operational aspects involved in EMS. The business is growing, it's evolving, it's maturing. But what we've included in there is the ability for agencies or entities to become accredited BLS training programs. If you're not accredited if you're doing an EMT class, there has to be an emergency EMS coordinator, education coordinator present physically.
An EC.
Each class, an EC, okay? If you're an accredited training program, let's say you have an accredited training program here, you select instructors, you can have subject matter experts, but you don't have to be physically present in each one of those classes. So it helps there. So the classes are becoming longer. The information that's required is becoming a little more in-depth. And that's just part of the growth of the EMS industry as we know it as a whole.
Is it becoming more in-depth, or honestly, is it really just going back to closer to where it was?
Well, for you and I, we are EMT ancients. We used to be EMT A's. We can say that because when we took our EMT program, there was a lot more anatomy and physiology, and this is how this works, and this is why this works in this fashion, and these are things that you need to look for. And then there was this movement towards, they really don't need to know that information.
It was they moved to a very psychomotor oriented thing and less clinical academic knowledge.
Correct. And I'm not sure what triggered the movement away from that back to the clinical knowledge.
Because it's no good.
But I guess they were finding in one state, you could be a first responder with 40 hours of training and be the attendant in charge in the back of the ambulance. That's how they were meeting their call volume needs. Taking somebody with 40 hours of training and sticking them in the back of the ambulance with a person who took a shotgun and blew themselves in the chest. Mm-hmm. And they're transporting 20, 30 miles. That's not very comforting.
We got, let's be honest, we got to monkey see, monkey do, monkey don't you dare think.
Right.
And that's what
and the community as a whole says, no, this is not what we want. We want people who can think on their feet. We want people who have some critical thinking skills to make decisions. For example, you have the protocols, the medical protocols actually should be medical guidelines, because not everything is black and white. Not everything is cookie cutter the way it presents. We've all had those patients who don't fit into that mold.
Sure.
And, have the ability for the EMT or the first responder to have some clinical judgment and make some decisions of what path we need to take and reach out and ask for that help when they need that help. So it's a lot more class, it's a lot more requirements. This is the way that the federal groups are moving. Virginia's been in the forefront of this for a long time. I know that National Registry is only going to allow people who take accredited training programs, paramedic, to be able to test at National Registry. And there's a lot of states scrambling, trying to meet those requirements. We're already there. We've been there. So,
how does this reflect on, if you look at the demographics in Virginia, certainly career departments are, jumping up and becoming quite numerous, but only in certain areas, really, if you look at it geographically. The majority of EMS care in Virginia, I don't know the number, but I'm going to hazard a guess. 80% of the care in Virginia is still provided by EMS providers. Mm-hmm. So as we go forward, and I'm not arguing that there isn't I firmly believe that there is a need for a more robust medical education for EMS providers, but conversely, that has got to have an effect on your ability for that other 80% that are frankly just hanging on with the requirements that they had before.
It's going to be a challenge, and that's why we think the advanced EMT will still be a basis, if you will, for a lot of the less commercial, less high volume agencies. But I will tell you that the career agencies are struggling because one of the things that also with these regulations, we actually now have a scope of practice under Section 1050 of the regulations, and that's new. And that reflects to the procedures and formulary that's posted on our webpage. And we didn't put the actual grid in the regulations. As you had said at the beginning of this program, it took 9 years to develop these. We don't want to take it 9 years if something comes out, a new widget. That's the best thing since sliced bread and canned beer that's going to save more lives. Take 9 years to get that into regulations. Sure. So this document's a living document that can actually be changed, in theory, quarterly, because it has to be approved by the Board of Health. So if your medical director wants to implement something new that's not on that grid or not part of that formulary, there's a process that they can go through to introduce it to the state medical direction. They approve it as a pilot, if you will. Goes to the advisory board, they say this is a great thing. Goes to the Board of Health, they said do it. Yeah. And they can include it.
If you have not looked at this, this is a particular page within the guidelines that I suggest you all have a look at. It clearly outlines the scope of practice for individual certifications. And there are several of them that have changed. Particularly things that were allowed in the past are not now allowed. So you should probably look at this just to make sure that you keep yourself on the right side of the wall of shame. Anything else you'd like to add as we come to the end?
So in closing, what I would share was I take the opportunity to read those. Or if they have questions, they can certainly call their local program rep or myself, and we'll be more than happy to answer.
And these are all available on the website.
Absolutely.
Anyway.
They're on our webpage in a Word document, on a PDF file, and actually you can go to the actual state registrar's official copy to see the language. So it's not just, well, they just wrote it because this is the way they felt. No, this is the language that's in the code. this is what the law of the land is.
Well, I hope you've all got something from this. It's certainly been for me. Even after reading these yesterday, I've learned some stuff today. Mike, thank you very much.
My pleasure.
All right. I'd encourage you all to have a look at this video afterwards. It'll be on our Facebook site, which is the County of Orange Fire and EMS, and also to have a look at our partner site, clinicalbraintraining.com and fire/EMSbraintraining.com. If you want a copy of this video, it's also available from video@orangecountyva.gov. Again, thank you very much. Goodbye.